I am your host for this webinar. My name is Joey Barnett. I am a partner at WR Immigration, and I practice in the EB-5 space. It has been a very busy month for most EB-5 attorneys and EB-5 investors, and really any immigration attorney for that matter, and we have a lot to talk about, so we're going to get right into it. I am joined today with Charlie Oppenheim, the man, the myth, the legend, who used to work at the Department of State for decades and decades, and he wrote the Visa Bulletin for a long time, and now he is working with us. Finn, could you move the next slide when you get the chance? And he is the director of our Visa Consulting at WR Immigration. Charlie, great to see you.
Great to be with you, everybody, today.
And we have a lot to talk about. There's been a lot of data that has been released by the Department of State, and it's great that we have Charlie here to help give us his insights and to help understand what exactly this means for EB-5 investors, both current investors who are in the pipeline, as well as future EB-5 investors. And so we're going to be talking all about that today and more. Finn, next slide, please. Please note this does not constitute any sort of legal advice or representation has been created just by you listening to our webinar today, but we are very pleased to speak with anybody about EB-5. You can reach out to us through the different areas on this slide here, or you can reach out to me. My email is jbarnett@wolfstorf.com. And next slide. WR Immigration, we are one of the top EB-5 firms in the United States. In the month of March, we filed over 150 new EB-5 petitions for EB-5 investors. Since the program began, we have helped over 5,000 immigrant investors and their families through EB-5, achieving green card success and getting to start their new chapters of their lives as citizens in the United States. So we have a lot to talk about, and we're just going to jump right into it. As always, we're going to talk a little bit about the Visa report for April that came out, but there's not too much in EB-5 that has really changed. But one of the big things that happened is they finally, the Department of State finally released this Table 5 in their annual report for fiscal year 2023. And that's one of the big things that we're going to be talking about. We're also going to be talking about this new process for post-RIA investors who have reserved Visa categories and how they are going to be able to get their Visa allocated. There is a new process that the Department of State has put together, which we're going to be talking about. And some of the things we're not going to be talking about today, but I might as well mention them just because there's so much happening in EB-5, is there's huge fee increases that are now taking place because it's after April 1st. So if you want to file an I-526E, you're going to be paying an $11,160 filing fee. That used to be $3,675. There's also the $1,000 EB-5 integrity fee. Additionally, at the I-829 stage, you're going to be paying a little bit more. The new amount is $9,525 for the I-829. For regional centers, there is a significant increase in fees, around $30,000 or so, for their I-956s and I-956Fs. And USCIS is using this money to help reduce their backlogs and get the money that they need to carry out their job, because Congress doesn't seem to be appropriating much money for them to do their job the right way. Additionally, there's new forms. So investors who are filing today, be sure you're using the new forms. The ones that were in existence before are still good to use for the next couple of months, but I would just recommend download the new form on USCIS's website. And then the last thing that we're not going to be talking about too much, but it is very, very interesting, and it kind of gets to the whole point of EB-5, is this sustainment period, how long you're required to keep your money at risk. There has been a lawsuit filed challenging USCIS's interpretive policy guidance, which said it only needed to be sustained for 2 years following the date that it has been made available to the job creating entity for use for job creation purposes. And there has been a lawsuit challenging that interpretation. I'm not going to speak too much about it or the pros or cons or what may happen. We have to see what ends up happening in court. But it is something that we are absolutely keeping our eye on because it impacts these post-RIA investors who have already filed their I-526Es. And what does that mean for their case? That's something that we're going to be tracking significantly. So let's talk about this annual report. Finn, next slide, please. And Charlie, let me just kind of give you the opportunity to talk, like, what are some of your big takeaways for EB-5 from this DOS annual report, in particular, this Table 5, which shows both the consular processing numbers and the adjustment of status numbers?
I think that these numbers are encouraging, showing that they were maximizing number use last year. Unfortunately, there are none of the reserved numbers are being used, only the unreserved. And it is extremely unfortunate that none of the reserve numbers are being used. They're, in a sense, being wasted. The lucky thing is, in the new bill, it allowed unused numbers from one fiscal year to be carried over one time to the next. So that is a positive. Yeah. What happens is the State Department must make estimates of how many numbers are going to be used when they're doing the August and September allocations. They have to take into consideration a number of variables such as potential extra demand for numbers, the return rate, etc. And they, in setting the September final action date, they attempt to come as close to the annual limit, ideally without going over. But there are times when their estimates may be a little lower than they should have been, resulting in, as it happened last year, then the annual limit being exceeded slightly. But the Immigration and Nationality allows for that because it tells the State Department they must make reasonable estimates in their attempt to maximize numbers under the annual limit. And in a way, it is much better that they actually went over because they had been far under in past years. Correct. And like I said, it's very hard because the September final action dates and the resulting allocations are determined in probably the first week of August. So the State Department, when they're making that determination, they're having to estimate how many extra numbers are going to be used in both August and September, and how many numbers may be returned in both August and September. In doing so, they look at historical patterns, but things change. And again, so their estimates may have been lower than they needed to be in terms of the amount of numbers being used. But again, this is a positive thing for any applicant being processed. And this process goes on for any of the categories, whether they be the employment fifth preference, the employment first preference, or any of the family categories. They do the same thing. And when I was chief, I would always prefer to err on the side of the applicant because it was a kind of a no harm, no foul. Nobody was penalized, or were not hurt by the fact that the annual limit was exceeded slightly.
All right, thank you, Charlie. That's very helpful. I mean, I think it's encouraging to see that DOS is doing what it can to issue those unreserved visa numbers. What we want to see now is them pushing those reserve visa number use forward as well. And that's something that we've been advocating for a while. And I'm hoping that we can start to see that in the coming months. The other thing that I just always am so interested to see is EB-5 is such a small part of U.S. immigration. And when you look at these annual reports, you see that it's really, really a small percentage of the total amount of green cards that are given out each year to foreign nationals. And I think it's like under 5% of all employment base and under 2% of all green cards. And so this program, it has a significant benefit to the U.S. economy and for job creation for U.S. workers. But it doesn't get as many visas as some of these other less skilled or potentially less beneficial visa uses. All right, this slide is very interesting to me because it shows the total number of unreserved visas that were used in fiscal year 2023. And once again, it shows that China is dominating the market and dominating the use. This obviously is from years and years ago where the I-526s were filed. But does anything jump off the page to you, Charlie, when you look at these numbers?
No, these are what we would have expected, like as you said, many years ago when China dominated the number use, often exceeding 75% of the number use under the annual limits. And we may see a return to that type of situation where China is, because they have the earliest final action dates or earliest priority dates, then they are able to take advantage of any unused numbers from the rest of the world, allowing them to expedite processing. And so this is a very positive thing. And again, it shows that state was trying to maximize number use last year.
I think it's also interesting to see the Vietnam number is only at 556 because we know that in the first couple of months of this fiscal year, they've already exceeded that. And we've talked about that in previous Chatting with Charlie webinars. All right, Finn, next slide.
And I think that,
go ahead.
No, I think the reason that was able to do, I think that a lot of those cases that were handled in October and November for Vietnam were carryover cases from the previous years.
We're going to speed through the visa bulletin charts. This shows, again, that the reserved visa categories remain current and that the unreserved is current for all except for China and India. Those dates didn't move forward at all in April. And let's go to the next slide, which has the dates for filing, which is Chart B. These are less relevant because USCIS has indicated that for those who are filing adjustment of status applications in the United States, you are only able to do it if you're current under Chart A. And so my question to you, Charlie, is do you expect USCIS to go back to using Chart B at all for fiscal year 2024? Or are we kind of in the Chart A now for the foreseeable future?
No, Chart A will be in effect, I believe, for the remainder of the year. USCIS, once they have stopped using Chart B during the course of a fiscal year, they have never reopened it. But I would expect the China and India final action dates, in theory, they should start advancing at a very rapid pace in order to maximize number use under each of the respective limits and also to approach these application filing dates, which is where the final action date should be in September or they're very close soon after.
Yep. Excellent. Okay, let's move to the next slide. All right, this is the new information that I'm very excited to report about. It originally came from the Department of State to the American Immigration Lawyer Association. There is a DOS liaison committee, which my partner Avi Friedman is on, and he helps submit these questions to the Department of State. And it talks about how those who filed and have approved I-526Es in the reserved visa category are supposed to move forward with getting their visa allocated abroad when going through the National Visa Center. And this process has never been very much clarified. And so we're getting it piecemeal. And what we are realizing, and we've actually started to receive some fee bills for post RIA EB-5 investors. And what they're doing is they're saying, go look at your I-526E approval notice. On there, it will say multiple visa categories, or what they call approved programs in there. It's either going to say reserved rural or reserved high unemployment area, and it's going to say unreserved. And what they're going to ask each individual to do is send an email to NVC's online public inquiry and say, hey, this is the visa category that we want to be allocated for. And so you would expect a lot of these folks, in particular Chinese and Indians, who would be subject to a backlog otherwise, are going to put, well, yeah, we want to be in that reserve category. And I imagine that we're going to be seeing most of everybody else who also filed in the reserve visa category putting that too. And so my question to Charlie is that the best way to do this? And I guess to go along with that is, what happens if it is current right now in the reserve category, but later becomes backlogged? Do you think there is a process by which you can change your, I guess, allocation election?
Yeah, it's an interesting issue. An applicant, say in the rest of world category, where they may be better off actually selecting the unreserved category, where the annual limits are much, much higher than they are in the reserved category, and the rest of world cutoff or final action date in the unreserved categories is current. I do believe there is a process in place which would allow an applicant to make a choice now and then change their mind if if the other option were to become more advantageous in the future. For example, they selected reserved now, and then it became in the, say, next fiscal year or a subsequent year to be processed in the unreserved category. I believe they could switch. And the reason I say this, in the family sponsored categories, in an F2B applicant, which is the son or daughter of a legal permanent resident, when the parent naturalizes, becomes a U.S. citizen, that 2B classification automatically converts to a family first, unmarried son or daughter of a U.S. citizen. In that respect, those applicants have the choice. Do they want to be processed in the family first preference, or do they want to be processed in the F2B category they were originally filed under? And they can go back and forth. So therefore, sorry for the rambling, but I think the people can make, if they're actually approved as reserved and unreserved, I think they can go back and forth, changing to whichever category is going to be most advantageous to the expedited processing of their case.
And that happens at the NVC stage. So once that case has sort of become documentarily qualified, do you think you would still be able to do it at that point?
Once an applicant becomes documentarily qualified, then at that point, if their case is within the final action date, if their priority date is within the applicable final action date, then the National Visa Center would then schedule them for a visa appointment in the upcoming month.
And if it's not available at that point because there has been a final action date imposed, you would think that you could go back to NVC and say, hey, actually, I want to be part of the unreserved category where there is no final action date or where my priority date is current.
Exactly right. And that is the process that is used in the family sponsored categories where applicants could potentially go back and forth between the family first and the family F2B preference categories.
Do you think it would potentially make sense for the Department of State to set defaults for EB-5 investors based on their country of birth and their visa category, as opposed to having the investor make that choice?
In a way, it potentially could expedite the process, but because I don't see any negative impact on a rest of world applicant if they were to choose, if they were to be automatically assigned in the unreserved category. Again, the annual limit in the unreserved category will typically be much higher than the reserved category that the applicant may have been approved under. Therefore, and the unreserved categories for rest of world applicants have historically been current. That may not be the case in the reserved categories once USCIS and the State Department begins processing the reserved applicants at a very high rate and the reserved annual limits start to go downwards.
So this new election process is something that is very new. It just started within the past week or so. And I think there's probably going to be some, what's the way to put it? Some time for the process to get finalized and to become smooth. And so in the meantime, there's probably going to be some communication with NVC back and forth. For example, we've received fee bills for Chinese nationals who filed in rural projects post RIA, and they've been assigned the unreserved category and told there's a backlog. Well, no, that's not true. They're in the reserve category and it's current, and they should be able to process the visas. And so, again, there's just these things that are coming up that we're going to have to be working with. One of the things that we have yet to hear is from USCIS and how they are going to be allocating these visa numbers. Because when an adjustment of status application is filed concurrently with the I-526, you put on the I-526 rural or high unemployment, but that doesn't necessarily get connected to the adjustment of status application. And so, we're having to communicate with USCIS, with the Immigrant Investor Program Office, or the service center where the adjustment of status is pending, and telling them, hey, actually, you can adjudicate this adjustment of status because it is current in these reserved visa categories. And I'm going to be writing an article about this. It's going to be published. And so be on the lookout for that if you have more questions. Charlie, anything else you wanted to add on this item before we move forward?
No, I think the only positive thing is this selection process. Right now, you can't go wrong with either way you go in the because all of the reserved categories are current. So if you were lucky enough to have an approved petition and allowing your case to be processed, there are plenty of numbers available in the reserved, and there are also plenty of numbers available for rest of world applicants in the unreserved category as well.
Thank you. And I guess that kind of gets to this whole point with, there's a lot of filings that happened before this filing fee increase occurred. We don't have the data to really say how many of these I-526s have been filed. But when it comes to the visa bulletin, and this is something that we've kind of harped on many, many times, it doesn't, DOS isn't going to see that demand until USCIS approves the EB-5 petition, right?
Correct.
And so that means that the visa bulletin will likely still remain current despite all of these new filings in the past month, because they don't have signals from USCIS that there's been enough approvals to create this demand that could potentially exceed the limits.
Correct. Yes, the State Department will only impose final action dates when the amount of numbers which have already been used during the applicable fiscal year and the expected demand will exceed the annual limit. At that point, they would impose a final action date to prevent the annual limit from being exceeded, but there is no indication that there will be any need for a final action date for the reserved categories during fiscal 2024 and well into fiscal 2025.
Thank you. That's very important to hear and something that I know a lot of EB-5 investors will be happy to listen to. All right, let's move to the next slide. Okay, this is another set of data that we have been anxiously waiting for. Every year, the Department of State releases its annual waiting list. And generally, these things are released a few months ago, but it just came out earlier this week. And it shows how many individuals, and this is not just the primary investor, this is also any derivative beneficiaries are waiting at NVC for a visa interview to be scheduled. And Charlie, what are your big takeaways that you see from this data that we've been waiting on?
This is very encouraging. For example, in the China total, that total is about 13% lower than it was at this time last year. So that lower total, combined with the amount of unreserved numbers which are potentially available for China applicants' use this year, could, in theory, reduce the China unreserved backlog by up to 25% during fiscal 2024 if the State Department is able to increase the rate of processing in order to maximize China number use under the fiscal year 2024 unreserved limit. At this point, the amount of China numbers being used is much lower than would have been anticipated and needed. And again, hopefully they'll be able to increase the rate at which China unreserved cases are processed in the coming months to greatly reduce this backlog. Again, I think it could be reduced by up to 25% if numbers are maximized during 2024.
And can you talk a little bit about what these numbers may mean for Vietnam and for India? And I just want to note for our viewers who don't see what it was last year, in Vietnam last year, the numbers were 1,534 were waiting. And now we see here it's less than 600. And for India, it was 1,362 last year, and that has actually increased to 1,652. So, Charlie, what are your thoughts on that?
Right. For Vietnam, I mean, this is very encouraging that they were able to process so many visas last year, and they've been able to process a high amount already this fiscal year. I think this, in a sense, guarantees that Vietnam should remain current in the unreserved category for the foreseeable future. The only countries in the unreserved categories, based on this information, that are going to require the imposition of a final action date in the foreseeable future are a continuation of the date for China and India. India, the amount of numbers available for them this year should significantly reduce this 1652 figure as well. So again, but for both China and India, the amount of number use on the under-reserved category needs to be increasing dramatically in the remaining months of this fiscal year. And I think that may only be achieved if the final action dates are to advance, allowing potentially more applicants to be processed.
Okay. And again, these numbers here do not take into account any pending I-526s with USCIS. So there is still this kind of, I don't know what we want to call it, invisible backlog, so to speak, that is based on pending cases at USCIS that this data does not reflect.
Right. The one good thing in that aspect is even if a case were approved at this point by USCIS, by the time it is transmitted to the National Visa Center, if the case is being processed overseas, by the time it reaches the National Visa Center, they send out all the required information for the applicant to eventually become documentarily qualified and the case to be scheduled. That is not likely to happen until the next fiscal year. Any processing by USCIS this point going forward is probably minimal. I think that one important thing that is on this chart is it mentions that there is no information provided in terms of the amount of reserved applicants that are on file at the State Department. That fact means they have minimal applicants on file. It is not worth them reporting it. And the last sentence in this chart, it indicates that state and USCIS anticipate using the reserve numbers next fiscal year. So again, that kind of is saying State Department and USCIS do not expect many reserve numbers to be processed this fiscal year, which is extremely unfortunate given the fact that we're already 2 full fiscal years into the new RIA program.
Yeah, it's very, very frustrating and actually leads us to our next slide. It's a great segue to our next slide, where we show our waterfalls and we can kind of put some information that we got finally from the 2023 annual report. But frankly, what this last sentence is showing is that these reserved visas, the ones that are in the light blue box, are going to go to fiscal year 2025 unreserved. And that's great for reducing the Chinese backlog for those who've been waiting since 2015, 16, 17, but it does impact the number of visas that are available for post-RIA investors who go in rural projects and high unemployment projects and could potentially extend their wait times for them to get a conditional green card. So it's a bit frustrating. The big change that we have in this visa allocations slide that we didn't have in the last one is if you look in the row for fiscal year 2023, we now know how many EB-5 numbers were used, and that's what that 9,817 number is. That's what we talked about at the beginning of the presentation. Those are all unreserved visas. No reserve visa numbers were used in fiscal year 2023. And that sort of separate orange box with the negative in front of it on the last column, that just is indicating that they actually exceeded the annual limitation because of the estimates, and they're allowed to do that under the INA. So that's really what this slide is different from what we've looked at it in the past. And I guess if I had looked at this a little bit more closely, we could have put that 4,478 into next year's unreserved visa category. And that will, expand and enlarge the number of unreserved visa numbers, which is great. But again, they are wasted for those who invested in the reserve visa category, which is a little disheartening to see. Charlie, do you have any other comments on this slide?
No, I think you're spot on. It is this chart shows the discouraging aspect of the fact that the reserve numbers are not being used. Again, it's been 2 years since the bill was passed, and we're not seeing any number use.
Right. And when those numbers carry over to the unreserved visa category, that really will limit how much is available for people who are filing today, because the worldwide limit is likely to get smaller and smaller towards that 140,000 sort of floor that Congress has set, right? It's not like this big bumper crop of visas is going to be coming again.
Correct. We've been lucky for fiscal 22, 23, 24 to have high overall employment annual limits. We're going back, starting with fiscal 2025, we're going to be returning basically to normal, probably have a worldwide employment annual limit between 140 and 150 maximum. I'm thinking probably more in the 145,000 level, meaning the reserved limits going forward are going to be much lower than they have been in recent years.
Right. Right. Okay, let's go to the next slide. Or that might be it, actually. Yeah, I think that's it. Finn, maybe let's go one more so you can put up our contact information on here. We hope this has been informative for everyone who is listening in. You can always reach out to us by scanning these QR codes, or if you want to just reach out directly at visalaw@wolfstorf.com, that's one way to do it. And my contact information, again, one last time, is jbarnett@wolfstorf.com. We are very active in EB-5. We have filed, I want to say, more than probably most law firms, and we're really on the cutting edge with these new topics. So if you're looking for great counsel to help you through your EB-5 journey, look no further than WR Immigration, and we are pleased to assist. So thank you, Charlie. Thank you, Finn. And we'll see you all next month.